Welcome to Medmark's webinar series. Today's presentation is titled Mitigating Product Liability Risk in the Era of COVID-19. I'm Kate Klaus, staff attorney in Medmark's Risk Management Department. On behalf of Medmark and today's presenter, Susan Bryce, thank you for joining us. Susan Bryce is a partner in the Chicago office of Brian Cave Leighton Paisner. She has over 25 years of experience managing risk for clients. She regularly advises clients on and litigates regulatory issues, product liability claims, toxic tort lawsuits, and environmental matters in federal, state, and administrative tribunals. She focuses her practice on areas that have a scientific aspect and routinely works with experts in epidemiology, genomics, toxicology, engineering, chemical fate and transport, and medicine. Ms. Bryce is the co-lead of BCLP's Toxic Tort Group, as well as its food and beverage team. Before I turn things over to Susan, I want to mention that Susan's colleague, Zeke Katz, participated in preparing this presentation and was scheduled to present as well, but his wife is having a baby today. We send our congratulations and wish their family well. And with that, I am pleased to turn things over to Susan.
Yes, thank you. I appreciate it. Yes, I have the interesting, woke up this morning to my co-presenter saying my wife is in labor. You have to do everything. So it is going to be interesting, but I've got this under control. So I'll take off right now. So let's start talking about mitigating product liability risk in the era of COVID-19. So since the onset of this crisis, we, along with others at my firm, have performed a deep dive into COVID-19 and all aspects of the legal landscape, including risks posed by potential product liability claims. For this webinar, I'll be focusing on the issues surrounding identification and mitigation of those product liability risks. And these will include, next slide, outlining potential product liability risks involving COVID-19, include product defect claims, marketing claims, advertising claims, breach of warranty claims, failure to warn. And I will also be covering some practical advice and steps for businesses to implement now to mitigate and defend against potential future product liability claims for COVID, including defenses for businesses supplying PPE, as well as some tips on dealing with causation, which in my mind is going to be the hardest thing here for plaintiffs to overcome. I'll also be covering aspects of the PrEP Act and its companion declaration by the Secretary of Health and Human Services, and most importantly, the provision on distribution of limitations that is in the declaration, which most of you might not be paying attention to, and a lot of people, I believe, are ignoring at their peril. It is something that has been overlooked by most people, and we've actually even talked to HHS about it this morning in more detail, and they confirmed it is a requirement under the declaration, and if you do not comply with it, you're going to not have immunity when people are bringing lawsuits against you. So in the end, I have some recommendations with respect to avoiding price gouging allegations. Just a few things at the offset. Well, it seems like COVID's been around a long time. I think we're all have that feeling. Litigation is just beginning. While product liability litigation on this front has been limited in the U.S., with the exception of sort of some false advertising and marketing claims and knockoff claims, we believe that it's going to just, this is sort of the tip of the iceberg in certain situations. So those involved in medical drug and device world need to be taking steps to ensure that they comply with the laws and, if possible, obtain immunity under federal and state law. Next slide, please. As you know, product liability lawsuits generally claim that a product is defective in some way and that the defect caused an injury, and the claims can be either in negligence or strict liability. And obviously, we're typically really worried about strict liability, but in this case, for various reasons, we think that the negligence claims would have more success than the strict liability claims. For example, there's a case involving food contaminated with norovirus where the court dismissed the strict liability claim because the food was not defective, but rather was contaminated by the negligence acts of the employees. And the court said the plaintiffs were left with a general negligence claim, pure and simple. And obviously that same sort of reasoning could apply to a COVID-19 setting. Some cases, on a different light, have found that certain medical products to be unavoidably unsafe and not subject to strict liability, relying on comment K of Section 402 of the Restatement of Torts, which generally excludes from strict product liability drugs in particular, which this is a quote, which in the present state of human knowledge are incapable of being made safe for their intended and ordinary use, but where existing medical experience justifies the marketing and use of the product despite the risk. This could be a particularly important defense in COVID-19 cases. But I have no doubt that people will try and bring strict liability claims, particularly with respect to medical products that fail to perform as intended or as claims, which do not have some sort of immunity via the PrEP Act or certain state laws. And we'll talk about the PrEP Act later briefly. And it's important to remember here that any business in the supply chain, from the manufacturer to the retail store, and anyone in between, that can be held liable in most product liability claims. Next slide. So what types of product liability claims might apply in the area of COVID-19? Well, pretty much all of them. You have product defect claims involving marketing and advertising representations. We've seen FDA and FTC already send out warning letters to companies alleging they were making false or unsupported claims about their product's ability to protect against or treat COVID-19. As you probably know, the Federal Food and Drug and Cosmetic Act provides that drugs and medical devices must be approved and cannot be misbranded. And FTC prohibits the advertising of products as being able to prevent, treat, or cure human disease without competent and reliable scientific evidence, and in some cases, human clinical trials to substantiate those claims. We've seen plaintiffs' attorneys piggyback on these warning letters and bring class actions that are based upon state consumer fraud statutes, false advertising claims, and the torts of misrepresentation and breach of warranty. And as well, states have also done the same thing. For example, in May, California brought an action against the company allegedly selling a fake drug, which was a paste comprised of radish, garlic, and herbs, and I'm not kidding on that, that claimed to prevent COVID. The state asserted claims for false advertising and violations of the FD&C Act. Similarly, in April, the state brought claims against the company for selling, quote, at-home COVID test kits. As we know, no such test kits have been approved by FDA. There's a particular problem here now with the sheer volume of products on the market making these false claims and creating big problems for people downstream. I've seen this particularly with the KN95 masks, which we have a client in particular that had bought some KN95s, which are from China. And the regulations of masks, as many of you might know or you might not know, has gone back and forth with FDA. They approved some of these from China, and then they said, no, we're not approving them. So people got stuck with a bunch of these KN95s that were approved under an emergency use authorization that was then rescinded and couldn't sell them. So as you can see, that's a big problem. And so there are some tips I have later on that can help you try and circumvent these types of situations. Secondly, product defect claims involving breach of warranties. As you all know, breach of warranties are express or implied, oral or written. They can include online content. They can be on labels. They can be on marketing materials. And as you know, there's implied warranties of merchantability and fitness for a particular purpose. And we have already seen a class action regarding alleged misrepresentations that include a breach of warranty claim. Next slide. So failure to warn. As we all know, these types of claims abound in the product liability arena in both the negligence and the strict liability context. Warning labels on the products, And packaging and owner's manuals must be clear and concise. The labels must explain all the possible dangers and risks that may be associated with the use of the product, particularly those that may not be immediately apparent to the average consumer. Obviously, you know, we have got a situation here where many consumers out there don't understand the transmission with respect to COVID-19. Even though it's all over the news, they don't understand it. And as we know, CDC has been going back and forth on that point, so you have to be particularly careful. That being said, manufacturers and sellers don't have a duty to warn of dangers that a reasonable user would anticipate. One example that we were thinking of is with PPE, for example. You could imagine a failure warn case involving a company failing to warn that certain PPE products were for single one-time use and that reuse posed an increased risk for contracting COVID. While that's obvious to healthcare professionals, probably not obvious to the average consumer. And there are examples of this in case law, in particular in HIV case law. In one case, a person died after contracting HIV from contaminated blood, and the court ruled that the manufacturer of the blood clotting factor was negligent in failing to warn the plaintiff that the product had not been tested for HIV. So in this era of COVID-19, it is important to provide accurate and complete warnings, and I'll discuss some tips on that in a minute. Next slide, please. Now we're going to talk about causation. This is, you know, where I think there is a lot to be, there's going to be a lot of defenses here, obviously, because a product liability case, you must show that the alleged defect caused their injury, and it's going to be very difficult to prove because the virus spreads quickly and sometimes silently. However, it will not be impossible to prove, and I'll give you some examples. First off, the workers' comp area is an interesting situation. Some states have made causation easier in workers' compensation area in that they have created a rebuttable presumption that employees who test positive for COVID contracted the virus while at work. Interestingly, in Illinois, that had been in place. Then it was revoked. Now the legislature has come out and enacted a provision covering the virus. The federal government has taken a tougher approach, somewhat not surprisingly. Through guidance, OSHA has stated that with respect to its record-keeping law, which is the OSHA 300 log for those of you that don't know, it will not treat persons as having contracted COVID-19 at work unless there is objective evidence that a confirmed COVID-19 case may be work-related, and that such objective evidence could include, for example, a number of cases developing among workers who work closely together without an alternative explanation, so a cluster of cases. And the objective evidence must be reasonably available to the employer. So as you can see, this is somewhat of a mixed bag in the workers' comp area, and perhaps not great for product suppliers, because if you think about the asbestos world, if a person is barred from bringing a workers' comp claim, is barred from bringing a claim because of the workers' compensation bar, they often look elsewhere, such as makers of the products that they're handling or premises liability claims, and any way to get at some money that's not subject to the bar. Next slide, please. This objective evidence standard that I'm discussing here, it's being used by OSHA, is akin to how courts have handled causation in prior disease transmission cases, such as those involving West Nile and Legionnaires. I have an example of a case where the court found that it was more probable than not that a person contracted West Nile from a mosquito bite at work, since he spent significant time at work during the time frame the virus would have been incubating despite the widespread outbreak elsewhere. With COVID-19, we can expect courts to take into account various factors such as incubation periods, transmission modes, and what we know about surface stability, when assessing causation. I'm going to talk a little bit about that on the science side here. So the consensus has been that incubation is no longer than 14 days. That being said, I've seen studies saying that could be really up to 21 days. So the science is not completely determinative on that, but because the guidelines have said 14 days, I think that that's a pretty safe assumption on the negligence front. Likewise, the science has evolved on transmission modes. I read a recent report indicating that it is much more likely to contract out indoors, as we all sort of assumed, but with 15 minutes of exposure to the person, or if it's a person-to-person, a respiratory droplet, 15 minutes of exposure to the person. That being said, you know, if you're trying to prevent something from inside ventilation, obviously helps. And then surface stability. This is a really interesting area that has changed quite a bit. The early studies showed that the virus didn't last more than 2 to 3 days on most surfaces. I believe it was 3 days on plastic and 1 day on cardboard. But that's changed recently. There was a more recent study out of China dealing with, and was published in the Lancet, dealing with surface stability at room temperature that called some of these findings into question. What they found was there was no virus on printing paper at 3 hours, on wood and cloth at 2 days, on glass and paper money at 4 days, but they didn't test day 3, so it could be somewhere between day 2 and day 4. And on plastic and stainless steel at 7 days, and again, they didn't test days 5 or 6, so there's some wiggle room in there. But as you can recall, the earlier study was 3 days on plastic. This one is at least 4 days. And then most surprisingly, the virus was present on the outer layer of a surgical mask at 7 days. And they found that smoother surfaces, there was more stability with the virus. So these transmission modes are ever changing. And interestingly, I don't know if you guys followed this, but CDC has gone back and forth on whether touching a surface is a clear mode of transition. Initially, they said that it was, then they sort of backed off of that recently, then they got criticized, and last Friday they came back out and clarified that it's a possible mode of transmission. So once again, all of that conflict's not going to be a huge help here. Next slide. Here we've seen this objective evidence standard employed by plaintiffs in COVID-19 cases so far. In one case, a plaintiff claimed he got the disease at a location due to a disproportionate percentage of individuals at that location becoming infected. And as you can see, that same idea could apply to a product. If you had a disproportionate number of persons who came into contact with a particular product getting sick. Next slide, please. Courts have also used scientific sampling to determine causation. For example, in Legionnaire's case, the court allowed the plaintiff's expert to opine on the source of the disease by matching the serogroup and subgroup of the particular Legionella bacteria found in the plaintiff with the bacteria found in a particular water source. This can actually also be done with COVID via genomics. And it takes a little explanation, but the virus mutates about every 2 weeks in very minor ways. The nucleotide changes, and it doesn't necessarily mutate in a way that changes the effects on the virus that the virus has in a person, like as in an isolate change. It's just sort of a small change, but one that can be sequenced through genomics. So if you had a sample of the genome of the allegation that this product caused me to get sick, you have a sample from the product and you have a sample from the person, and you compare the genetic sequences. If they aren't the same, then you have a decent defense that the virus was not transmitted by your product. But if they are the same, the plaintiff then has some ammunition, so there's some risk involved here. As I said, the longer this goes on, the more mutations that are out there, which increases the possibility that you would not find a match unless the person actually contracted the disease from your product. All that said, kind of contrary to what I just said, as the virus becomes more widespread and the country opens up, there will be more ways to contract the virus, generally making it more difficult to prove causation, especially without samples. Next slide. So here's some advice on mitigating and defending against potential product liability claims. And I'm going to talk about marketing claims first. Number one, carefully vet marketing materials that are placed online and instructions at stores and on labels, and support the marketing claims with competent and reliable science. I cannot stress that enough. Avoid ambiguous statements. There's a difference between, quote, kills most germs versus, quote, kills 90% of germs versus, quote, kills 90% of known germs that can cause disease. You have to look at this through the lens of a consumer. Third, due diligence your suppliers and ask them and ensure that they are providing you with FDA-approved and authorized products, even if through an EUA. And I'd have them make representations to this effect so you don't get in the problem that the people have found themselves holding the bag with these KN95 masks. Now, granted, in that situation, the representation would not have helped necessarily because the FDA yanked the EUA, but at the same time, there's a lot of stuff floating around on the market that is false and not correct and doesn't have the right authorizations. So make sure that what you're getting is authorized in one way, shape, or form. Follow the requirements for labels, marketing, and advertising, obviously, and promotion that are included in any emergency use authorization. As you all likely know, the way most of these new products are getting approved are through emergency use authorizations. For example, there is a face mask umbrella EUA that has a number of requirements, and importantly, it has pieces to it that say you must say this, and then there's other pieces that say you cannot say this. So inside that EUA are very specific instructions as to what you can and cannot say, and some things that you must affirmatively say. Again, stay away from claims specific to COVID-19 unless approved by FDA for such use, and make sure. And interestingly, in the umbrella EUA, one of the things they make you say is that this is authorized pursuant to an EUA and only is as good as, only is authorized for the term of the declaration, for the declaration of emergency. So that's something to take into consideration. Next slide, please. Breach of warranty, these are fairly easy. Disclaim any and all express and implied warranties conspicuously, as you know, sort of capitalized, bold, et cetera. I would consider including a specific express disclaimer if applicable for COVID. And I would say it this way, I would call it SARS-CoV-2, like I have here in the slide, and any viruses mutating therefrom, or COVID-19, because as you can imagine, there might be a new virus and you don't want to have to revise your disclaimers. Consider excluding third-party beneficiary coverage from contracts to the extent allowed by law. And as noted, be careful how you represent what your product can and cannot do. Next slide, please. So failure to warn, here's some specific steps you can take to reduce your failure to warn risk. With respect to PPE, devices and drugs used to treat the virus, consult FDA guidance and consider providing specified warnings about COVID, such as warning that your product, if this is true, is not intended to prevent, treat, cure, or mitigate the spread of SARS-CoV-2 or any virus mutating therefrom or COVID-19, unless you are positive you have conducted the testing and have FDA approval. If you're going to do that, I would highly recommend consulting counsel on that front. In some cases, however, a product such as a nebulizer could increase the spread of COVID-19, and in that case, you would want to warn about that. With respect to test kits, consult FDA guidance and consider warning about false positives and false negatives. And even with respect to drugs and devices not intended to be used with COVID-19, consider warning about virus transmission based upon the surface stability studies, such as, if it turns out it is 7 days, and you might want to hold some things back for an extra day or two before you send it out, just to sort of decrease the likelihood that there's going to be transmission of the virus. But you might want to slap a label on there that basically says something. But that's up to your discretion. It's just something to think about, depending upon a lot about your certain factual circumstances and what kind of products we're talking about. That in particular would come into play, obviously, if there is someone at your manufacturing facility or distribution facility that became ill with COVID, and you know that they came into contact with product or packages before they left your facility. In that situation, I think you probably have a duty to warn in some measure, and perhaps take other measures that you might need to take other measures depending upon various factors, such as whether the person handled the product or packaging, how the product is used, the transit time to reach the consumer, the type of packaging, that sort of thing. But again, I would consult counsel in determining if you've got yourself in that situation, because so much of it depends upon what kind of product we're dealing with. Note that OSHA and states have very specific laws regarding how to manage COVID-19 cases in the workplace. Because I'm in Chicago, I can just say specifically for Illinois, or actually Chicago, they've got all sorts of rules about what's going on in the buildings, and how you having very, very detailed about signage and other things. And so you have to pay particular attention to that if you have manufacturing facilities, the OSHA laws, as well as the state OSHA laws, as well as the local laws and the CDC laws and guidance. Okay, so a few other things to talk about and to generally ward off and defend against product liability claims. Follow CDC, OSHA, FDA, FTC, and state and local evolving guidance. Like I just said, I believe courts will rely on these to inform the standard of care in negligent suits. 2, immunity. Ensure that your product meets the requirements for immunity under the Prevactin Declaration. That immunity is broad but complicated, and it's best to consult counsel on it to make sure that you've got it. Preemptive sampling, we talked about that. Although unique, it's something to think about depending upon your circumstances. It's been done in hospital settings, and there are some standards and protocols out there for it. And on that point, obviously, that kind of sampling has to be done by somebody properly certified and credentialed, and by a lab that can handle human pathogens. Next slide. Some real simple things, obviously, sound record keeping, detailed records regarding employees' whereabouts at specific times, detailed records regarding products, samples, lot sampling, sick employees following the guidance as we discussed a few minutes ago, including isolating them and taking steps to limit the spread. Insurance notification. Notify your insurer immediately when a claim has been made. Even if you don't think you have insurance, coverage for that particular claim, notify them. I cannot tell you how many times a client has come back and said, I know we don't have coverage for this. And I'm like, no, just submit the notification, and boom, you end up getting coverage. Even in asbestos situations, I've run into that. So it's worthwhile at least trying. And a lot of times the coverage depends upon the fine print, right? The exclusions and the definitions, and that is something that, is not easy for the average person or the average lawyer to understand. Review your insurance policies. See if you need to boost your insurance, or if there's something you can do at this point to change your insurance policy to cover COVID exposure and business interruption in particular. And then review contracts in the supply chain, evaluate your risks in your supply chain, enter into and revise contracts that allocate risk appropriately with vendors and customers, including indemnifications. And this goes back to, the point of having, products out on the market that are completely not approved by FDA. And you definitely don't want to end up holding the bag. Next slide, please. Employee training protection, obvious. I'm just going to whiz through this. you know, obviously think about giving your employees extra precautions, gloves, masks, so to increase the likelihood that the product leaves your custody or control in a non-contaminated state. That being said, there are OSHA rules on PPE that are very complicated, including mandatory and voluntary use of face masks and respirators. These need to be consulted, and they are very complicated. And I think that it's even out there in the literature, people are still, because some states are mandating face masks, having trouble reconciling that with the OSHA rules. Again, hygiene, important, training, that's obvious. And then some other defenses that might come into play, lack of duty, defect didn't cause the injury, contributory negligence, assumption of risk, disclaimer of warranties, and substantial change from when it left your control. So if it got contaminated after it left your control, you know, you theoretically have a good defense there. Okay, now I'm going to talk about the PrEP Act. So the next slide, and I'm going to go through this stuff fairly quickly because I imagine most of you know something about the PrEP Act. The PrEP Act and its accompanying March 17th, 2020 declaration provides certain immunity for medical product manufacturers and distributors, as well as people that they name program planners and qualified persons from legal action. And this includes tort actions, federal and state law. And so the immunity is very, very broad. It doesn't cover injunctive relief, and it does not cover enforcement action from the federal government. But first off, something really important to know, the PrEP Act and the Declaration must be read together, as the Declaration can expand and contract the coverage provided under the Act, and it does in this case, which is one thing I don't think a lot of people understand. Here, the Act and Declaration together provide that covered persons engaging in recommended activities are immune from suits from an individual that incurs a loss caused by the administration to or use of a covered countermeasure consistent with the terms of the declaration issued under the Act. A lot of these are defined terms, and complying with these defined terms is imperative. Luckily, a covered person is very broad and includes manufacturers and distributors of covered countermeasures. Recommended activities are the manufacturing, testing, development, distribution, administration, and use of the covered countermeasures. Next slide. So what are the covered countermeasures? They must meet two requirements, and I have them up here. They must, it can be an antiviral or other drug, biologic, diagnostic, or device or vaccine used to treat, diagnose, cure, prevent, or mitigate COVID-19 or the transmission of SARS-CoV-2 or any virus mutating therefrom, there's that language, or any device used in the administration of such. That makes you eligible to be a covered countermeasure. Then you have to meet the second part of the definition. You have to be either one of three things: a qualified pandemic or epidemic product, which is defined in the Act, a security countermeasure, which is defined, I believe, in the Declaration, or drugs, biologic products, or devices authorized for investigational or emergency use, as those terms are defined in the PrEP Act, et cetera. So you have to meet both of these definitions in order to be a covered countermeasure and come within the ambit of the PrEP Act. As some of you may know, Congress recently broadened the scope of immunity here to include masks that are approved by NIOSH. But in most circumstances, this product must be FDA approved or authorized in some fashion. And as noted earlier, most people are using the FDA emergency use authorization process to get their products covered. Next slide. So limitations of distribution. Okay, this is the important part I was mentioning earlier. This is Section 7 of the Declaration. It is not in the PrEP Act itself, but the PrEP Act makes clear that the Declaration can alter the limitations of distributions if you read it very carefully. Most guidance out there doesn't talk about this section, including guidance from the government. However, there is the advisory opinion that came out on April 14th, 2020 does talk about it. And we have been working with a number of clients to figure out how to actually comply with this provision, because essentially it says that in addition to everything else, your activity must be pursuant to a federal contract or other federal agreement, or, and I'm going to read actually the actual language, which I don't have quoted here, it must be an activity authorized in accordance with the public health and medical response of the authority having jurisdiction, which is a defined term, to prescribe, administer, deliver, distribute, or dispense the covered countermeasures following the declaration. Okay, so there's a lot of words there, but authority having jurisdiction is defined, and I'll get to that. So this non-binding advisory opinion, which is sort of one of the first places and only places that actually talks about this, explain that these conditions are to be interpreted broadly and include any arrangement with the federal government, any activity that's part of an authorized emergency response at the federal, regional, or state or local level, including guidance, requests for assistance, agreements, or other arrangements. Now, that's just clear as mud. And we have tried on numerous occasions, and actually, as I mentioned earlier, talked to HHS today about a number of things. For example, is an emergency use authorization, which I can't say that word for some reason, is that enough? If you have an EUA, is that enough to meet this requirement? And they were skeptical as whether an EUA would be enough, even though it is something that's being authorized by the federal government. Now, I'll tell you what is covered, and something that I worked on was the GM ventilator project. We worked with a subcontractor on that project, and we weren't concerned about this because what we had at issue was an agreement with the federal government. So what we have been telling a lot of clients is it's worth considering getting a letter or entering into a memorandum of understanding or something along those lines from the authority having jurisdiction, authorizing you to conduct the activity, which I understand seems very silly. Like, I'm manufacturing a product, I have to go to the state of so-and-so and get authority and authorization to manufacture and distribute this product. But no one can tell us that that's not what has to be done. And an authority having jurisdiction is not just the federal government. It is HHS, but is also the public agency or its delegate that has legal responsibility and authority for responding to an incident based upon political or geographical or functional range or sphere of authority. So, for instance, in a situation where a client was working on doing its own test kits and for its employees, we talked to them about going to the state with respect to getting an MOU authorizing the entire program and all the actions within the program in order to come within the ambit of the PrEP Act. So I'll move on now to the last part here, and we're going to cover price gouging really quickly. And this is something a lot of people don't think about because you don't necessarily think or know that you're price gouging sometimes, because that price gouging comes into place when there's emergency declarations, and it's not that often that we have emergency declarations. So how do you know if you are price gouging? Well, price gouging occurs when a seller raises their prices for goods to take advantage of increased demand, often after a state of emergency has been declared, such as COVID-19. But importantly, your business can be engaging in price gouging and not know it, as it can simply occur because the demand for your product has increased and you have raised the prices of your products accordingly. That being said, price gouging typically doesn't happen if your prices are raised in response to increase in expenses, such as raw materials or transit. You're allowed to generate profits, but you have to be careful here. There are both federal and state laws that apply to price gouging, and unfortunately, there is no preemption. So there is a federal executive order. There is not actually a law in place yet but there's a federal executive order, and then there is a patchwork of state laws covering price gouging. And so if you were selling, into numerous states, you need to be thinking about how their price gouging laws operate. Next slide, please. As stated, most price gouging laws occur during a state of emergency, and generally, they apply to a lot of things. Most often, obviously, PPE and medical products, and sometimes consumer products. Some of them are very broad. Gasoline, food, other things are covered by these price gouging statutes. So what are the penalties? They vary. Most often, they impose civil penalties per violation at each sale of a product. Can, in some states, be deemed to be a separate and distinct violation. So it could get hefty there. And some price gouging laws also include jail time as a potential punishment, but I don't think that that's going to happen except in extreme and obviously knowing situations. Finally, how are these violations exposed? Consumers and businesses filed price gouging complaints. DOJ has a website for reporting at the state level. The complaints are made to the state's attorney generals. And so I'm going to talk a little bit on the next slide about the current state of the law. There's a federal executive order. The executive order prohibits any person from, and this is somewhat strange, but this goes back to the way the earlier law was done, accumulating designated materials either in excess of the reasonable demands of business, personal, or home consumption, or for the purpose of resale at prices in excess of prevailing market prices. This is the one that DOJ went after a bunch of people, I believe, in New Jersey and New York on that were hoarding masks and selling them at exorbitant prices. The materials listed include medical devices, medicines, PPE, disinfecting devices, and products used in a clinical setting. Congress has been working on legislation that would allow for actually a statute on this and more stringent enforcement, but unfortunately, at least as of a few weeks ago, none of those had a federal preemption provision in them. Everybody seems to want to give states their own authority in this area. So here's some examples of the states on the next slide. And unfortunately, some of this is backwards on the slide, so I apologize, but it says strict, but it should say broad. Some states define the price gouging broadly. Connecticut, Georgia, Louisiana, and Mississippi's laws do not allow for any increase in a product's prices during states of emergency than the prices that were charged immediately prior to. But again, as stated, most of these laws allow you to take into account any increase in your costs incurred in producing and selling the product. Georgia, for example, says, quote, such price may be increased only in an amount which accurately reflects an increase in cost of the goods or services to the person selling the goods or services, or an increase in the cost of transporting the goods or services into the area. And then other states are more narrow. Some of these states prohibit the sale of covered products during a state of emergency for more than a set percentage above the pre-emergency sale price. California is one of these, and it defines price gouging as selling certain covered consumer items, including gasoline and food, for more than 10% above the price charged prior to the emergency. And then there's a third group of states that use a reasonable standard, and New York is one of them, and New York forbids selling products for, quote, an amount which represents an unconscionably excessive price. And it does have some examples of what that might be, but again, that's open to interpretation somewhat. I believe there is some case law on that. So here are some tips with respect to price gouging. As I stated, of utmost importance, there is no preemption here. So if you sell products across the U.S., you need to be aware not only of the executive order, but also of this patchwork of state price gouging laws, because you could be called out for price gouging simply because you increase your profit margins on these scarce products. One strategy to comply is just comply with the strictest state standards. that do not allow for any price increase taking into consideration costs. Another tip here is obviously educate your procurement, marketing, and sales teams on this issue, and perhaps revise your contracts in a way to avoid people upstream price gouging you or people downstream price gouging and getting indemnification from that if it somehow flowed back to you. And, you know, a lot of contracts have, I'm sure that I am complying with all laws. Well, that might not be the case at this point. So this might be something you want to call out to your suppliers if you end up in that situation. So I'm going to call it a day. And I appreciate everybody listening in to all of these topics. And again, my name is Susan Bryce. I'm at Bryan Cave. And I'm sorry to say Zeke was not here with me, but he is also a great resource. And I have both here my work phone and my cell phone as I'm operating off my cell phone right now, as does Zeke. And we appreciate MedMark giving us the opportunity to talk to everybody and hope that everyone stays safe. Thank you very much.
Thank you so much, Susan. We do have a couple of questions for you from our listeners if you have a moment.
Okay.
The first one is, could you explain a little bit more about the face mask umbrella EUA?
Sure. So the face mask umbrella EUA is a product of, as I noted earlier, the back and forth that occurred with the KN95 masks, and I believe it's dated April 24th, 2020, and it deals with any kind of mask that is used for source control. So it could even be cloth masks. And source control means it covers your nose and your mouth, but it's not intended, it's intended not to be sort of a barrier for liquids necessarily. But the really important part about that is, as I said earlier, there are a lot of requirements that you have to comply with in order to fall within the face mask umbrella EUA. And this would be, and you don't have to take any steps necessarily. Unlike a lot of EUAs where you have to go get the EUA, this one is supposed to cover, that's why it's the umbrella EUA, a number of different situations. But there are very specific labeling requirements, very specific requirements relating to advertising and promotion, as well as the labeling requirements. And they're specific, and some are, affirmative, and some are things that you can't say. So if you're involved in face masks, I highly recommend you take a look at that umbrella EUA.
We have another question that's sort of along the same lines. They're asking about state and city requirements that people wear face masks in public, the non-surgical, non-N95 masks, and whether there is PrEP Act protection for manufacturers of these face masks intended for the general public.
Yes, I think that there is. I'm looking at this right now. It's with respect to being authorized only for source control, it can be used for the general public as well as used for the in a healthcare setting. But obviously, if you comply with everything, but that's part of the umbrella EUA, is the idea to try and help people get into the business and promote the making of face masks. But you have to have all those labeling requirements, and you have to comply with all the distribution, promotion, and sales provisions. But it would seem to apply given what it says in the coverage provision. I believe it's on the second page of the EUA in the beginning.
Okay, and one last question. What is involved in obtaining a memorandum of understanding or a similar approval letter from an appropriate government authority?
Well, good question. It's what we have done in a couple of situations is just reach out, had the client, here's an example of somebody who was using and this isn't in a manufacturing context, but they were leasing their parking lot for a drive-by test clinic. And we had the town that was asking them to do this write them a letter with 3 or 4 sentences in it that I drafted up to say, we authorize you to engage in this activity. And it came from the town's authority having jurisdiction, entity that qualified as the authority having jurisdiction. But in a more broader sense, you could do a memorandum of understanding, but you need to reach out to the states and the cities and or the federal government, depending upon your situation, and ask them for this. Unfortunately, they are as confused by it as everyone else is. But I can tell you, having been on the phone with HHS, they are not. No one is taking the position that this does not apply. And so you've got to figure out some sort of way to fall within this limitations of distribution section.
Thank you very much, Susan. I know your presentation will be valuable to our audience, and we appreciate you stepping in for Zeke as well. Please give him and his wife our best. Thank you for joining us. This concludes today's webinar.